Most people don't like talking about death. We change the subject. We joke about it. We say, I'm still young, or I don't have much anyway. But death is the one appointment no human being has ever successfully cancelled. And here's the uncomfortable truth. If you don't decide what happens to your property, the law will decide for you. A will is not about dying. A will is about control, responsibility, love, and clarity. It is about making sure that when your voice is gone, your wishes are still heard. Today, we are going to talk openly and deeply about what a will really is. Why every adult, rich or poor, needs one. What happens when you die without a will? Whether a will can be cancelled after death. And the painful, real-world reasons why wills are challenged, overturned, or ignored. This is not legal jargon. This is a human story, one that plays out in families every single day. So, what exactly is a will? At its simplest, a will is a legal document in which a person states, "This is what I want to happen to my property, my money, my responsibilities, and my dependents after I die." But that definition is far too small for what a will truly represents. A will is a final instruction. A map for your loved ones. A shield against chaos. A voice that speaks after silence. Legally, a will allows you to 1. Decide who gets your property. 2. Decide who does not get your property. 3. Appoint an executor. This is the person who carries out your wishes legally. 4. Name guardians for minor children. 5. Give specific gifts like money, land, and sentimental items. 6. Express personal wishes, including burial preferences, where allowed. Without a will, none of this is guaranteed. Under Section 3 of the Law of Succession Act, Cap 160, Laws of Kenya, a will is a legal declaration by a person legally referred to as the testator of their intentions regarding the disposal of their property after death. Let's simplify that. A will is a written or oral instruction made voluntarily by a mentally sound adult, explaining who gets what after you die. It does not take effect while you are alive. It speaks only when your voice is gone. That is why courts treat wills with seriousness, because they are the last instructions of a deceased person. Let's explore the types of wills recognized in Kenya. Kenyan law recognizes two main types of wills. 1. Written wills. This is the most common and safest form. Under Section 11 of the Law of Succession Act, the written will is valid if the testator is 18 years or older. The will is signed or marked by the testator. The signature is made with intention. The will is witnessed by at least 2 competent witnesses. The witnesses also sign the will. Important detail: witnesses should not be beneficiaries. If they are, their gift may be invalidated. 2. Oral wills. Yes. Kenyan law still recognizes oral wills. But listen carefully. Under Section 9, an oral will is only valid if made before at least 2 competent witnesses. The testator dies within 3 months. Or if the testator is in active military service. This type of will is extremely risky, easy to challenge, and often rejected in court. If you take nothing else from this episode, avoid oral wills. What common myths exist about wills? That wills are for the rich. This is one of the most dangerous myths in society. You don't need millions to need a will. If you have children, a spouse or partner, a house or land, a bank account, a business, livestock, a car, debts, or even personal belongings that matter, you already have an estate. And estates without wills don't disappear, they become battlegrounds in case of death. In Kenya and many other countries, most inheritance disputes do not involve billionaires. They involve a single plot of land, a modest house, A small business. A pension. Or a bank account no one knew about. It's not the size of the property that causes conflict, it's the absence of clarity. Why you need a will. Even if you're young. Let's be honest. Most people think wills are for later. Later when they're older. Later when they're sick. Later when they've made it. But death doesn't wait for financial milestones. Point 1. A will protects your loved ones. Without a will, your family may wait years before accessing property. Accounts may be frozen. School fees may stop. Businesses may collapse. A will allows your family to grieve without also fighting the system. 2. A will prevents family conflict. When there is no will, people don't argue about law, they argue about love. Dad loved me more. Mom promised me that land. I sacrificed the most. Grief amplifies entitlement. Silence breeds suspicion. A will replaces guessing with certainty. 3. A will lets you decide, not the law. If you die without a will, you die intestate. That means the law decides who inherits. The law decides in what proportions. The law decides who administers your estate. And the law does not know your family dynamics, your estrangements, your promises, your intentions. The law is neutral, your life was not. 4. A will protects children. If you have minor children, a will is not optional, it is essential. A will allows you to appoint guardians, create trusts, decide how and when children access property. Without a will, guardianship may be contested. Children's property may be mismanaged. Vulnerable dependents may suffer. 5. A will is an act of responsibility, not fear. Writing a will is not pessimistic. It is the adult equivalent of locking your door at night, not because you expect danger, but because you respect reality. A very important question to ask. What can you include in a will? A Kenyan will can include land, houses, vehicles, bank accounts, shares, businesses, livestock, personal items, digital assets, burial instructions, guardianship of minor children, appointment of executors. Yes. Even who manages your children if you die. What you cannot do with a will. This is critical. A will is powerful, but not absolute. You cannot, 1. Disinherit dependents without cause. Under Section 26, courts may interfere if dependents are left out unfairly. Dependents include spouse or spouses, children, former spouses maintained by the deceased, any person maintained immediately before death. 2. You cannot dispose of property you don't own. You cannot give away family land you don't legally own. Property held in trust. Property already transferred. 3. You cannot override mandatory legal rights. Marriage, trust law, and land law may limit what you can distribute. Now, on to the scary question. Can a will be cancelled after death in Kenya? This is the question everyone asks. And the answer is sadly yes. A will can be cancelled, altered, or declared invalid after death. But not casually. Only for specific legal reasons. Let's break them down. 1. Lack of mental capacity. A will is invalid if the testator or maker did not understand what they were doing, was mentally ill, was intoxicated, was suffering from dementia, could not comprehend the extent of their property. Courts often rely on medical reports, witness testimony, timing of the will. 2. Undue influence or coercion. If someone forced the maker or testator, threatened them, manipulated them, took advantage of illness or age. The will can be set aside. Common Kenyan scenario: a caregiver influencing an elderly parent. 3. Fraud or forgery. If the signature is forged, pages are altered, witnesses never existed, the will collapses entirely. 4. Improper execution. If Section 11 requirements were not met: missing witnesses, witnesses didn't sign, witnesses were beneficiaries, the will may fail. 5. Revocation before death. A will can be revoked or officially be cancelled if a new will is written. The will is destroyed intentionally. The testator marries, unless made in contemplation of marriage. Yes, marriage automatically revokes a will under Kenyan law unless stated otherwise. 6. Failure to provide for dependents. Even a valid will can be interfered with under Section 26 if dependents were unfairly excluded. Provision was unreasonable. The court does not cancel the entire will. It adjusts it. Who can challenge a will in Kenya? Only specific people have legal standing: spouse or spouses, children, dependents, beneficiaries, personal representatives. Strangers cannot challenge a will. This is how courts handle will disputes. Kenyan courts aim to balance testamentary freedom, protection of dependents, public policy, justice and fairness. Courts prefer upholding wills, not destroying them. But only if the law was followed. The will reflects free intention. How to reduce the risk of your will being cancelled. You cannot control everything, but you can reduce risk. 1. Use a lawyer. Professionally drafted wills carry more weight. 2. Ensure mental capacity is clear, especially for elderly or ill testators. 3. Avoid secretive changes. Transparency reduces suspicion. 4. Explain unusual decisions. A short explanation can prevent long litigation. 5. Update your will regularly. Marriage, divorce, children, property: update your will. So, what happens if you die without a will? This is where things get painful. When a person dies without a will, the estate falls under intestacy laws. That means family members must apply to court for authority to deal with your property. Here, delays are common. Disputes are frequent. Costs increase. Relationships suffer. In Kenya, the Law of Succession Act determines who qualifies as a dependent, who inherits first, how property is shared. But here's the issue: statutory fairness is not the same as personal fairness. The law cannot reward caregiving, sacrifice, emotional bonds, cultural nuance. It only recognizes categories. A will is not just a legal document. At the end of the day, a will is a mirror. It reflects your values, your relationships, your sense of responsibility. It is the last story you tell about who mattered to you. Your silence is also a decision. If you do nothing, you are still choosing. You are choosing to let the law speak for you. Writing a will is not about death. It is about love, foresight, and dignity. And perhaps the most powerful truth of all: a well-written will doesn't just distribute property. It protects relationships. You can live clarity or confusion, peace or litigation, unity or division. The choice is yours.